Hi, good morning. No worries, I'll keep us all right on schedule. My section is very short. This tax practitioners meeting, not for the fact that we haven't had some decisions like Colin had said come down, but for purposes of this particular group, I'm just highlighting one decision, which is the Pepsi decision. That's the first one listed, and the second one is the WinPoint Partners case that's currently pending in the tax tribunal. With regards to the Pepsi case, I don't know if anyone follows it, but we had a dispositive decision on the underlying substance issue, which was an 80-20 issue. And that had to do with whether or not, without getting into too much of the weeds on this, because it was a very intense factual record. It's years of litigation in the making. And so that decision, like I said, came down on May 4th of 2021. And it just briefly had to do with the inclusion or the exclusion of a subsidiary of Pepsi. And so whether or not the 80-20 rule would apply. The department won on that motion. And so what the litigation that proceeded after that was just on the penalties that were associated with that issue. And these are, not only was that issue a high dollar issue, but also, as you can imagine, then the penalties were a high dollar issue. So that was, again, fully briefed. It took, there were a lot of facts that went into specifically what penalties, number one, what the amount was, and different factual aspects of those penalties. And so that was briefed, and then it was finally decided. That decision was issued this was one of the ones that Colin had referred to, was issued on September 12th of this year. And it's a 12-page decision. It's docketed under those two docket numbers. If you pull up the first one on the tax tribunal's website, under they have a section on there. It's orders and decisions. So if you wanted to read it, it's a short read, but I'll highlight it. We won. That's all we need to say. No, it was a great case, I think, for the imposition of penalties. And for many of you that practice before us, a lot of times penalties tend to be something that's negotiated depending, again, on the facts and circumstances of each case. This was one case that we felt very strongly that what the taxpayer had engaged in was not ordinary business care. And so if you look under the regulations, the section under whether reasonable cause applies. And so if you're asking for penalty reduction or abatement, you will come to us and say, hey, listen, here's how we fit the definition, or here's how our circumstances fit, whether we were a good taxpayer, which we did argue. This was one of the facts that, or arguments that the department did present. And to be fair, the ALJ, or the tax tribunal judge, did find that they did present a fairly compliant history. However, on the whether or not they exercised reasonable, prudent business care, that was basically the 12 pages of his decision saying that they did not. And I will just finish my discussion of this case. There's a paragraph on page 11 of the decision by that judge, and I'll just read it because it pretty much says it all. So the judge said it's astounding that a sophisticated tax department like PepsiCo's would create an aggressive tax strategy to create a non-operational shell company named PPM LLC, whose sole purpose was to make billions of dollars of FNLA's, that's their Frito-Lay North America's domestic snack line income, previously recognized for state of Illinois income tax calculations, disappear with a few strokes of a pen without addressing the merits of such an endeavor with an in-depth factual and legal analysis. And so therefore their plea to have penalties reduced or abated failed. So that was Pepsi, and that is another case. There's one docket that's on hold in the tax tribunal, the follow-up audit cycle, and then the next audit cycle is one of the cases that was filed down in circuit court on the Protest Monies Act in Sangamon County. So that one is kind of just same issues, and is just, the litigation has just started on that. Next is the WinPoint Partners cases. There are 6 of them pending right now. They're all related at the tax tribunal. I can't get into a lot of the strategy or substance of these, but to know that they all generally cover the same time period, which is 2014 to 2016. They all involve disputes over whether the entities that were involved in a trade or business for purposes of the IITA. And so that would require that their income be treated as apportionable business income. Also at issue is whether they fit the statutory definition of investment partnerships, which that is contained in our statute in 1501A, little a 11.5 into the safe harbor exemption. And therefore, if they would be exempt from replacement tax. The taxpayer's position, obviously, is that they were passive investors and their income is non-business income, and that this income should also qualify for the exemption from replacement tax under that safe harbor provision. The department's position is that the taxpayer conducted an active trade or business and that their income was, in fact, business income, and that they do not qualify for the replacement tax safe harbor. There's also an issue with respect to whether then the entities qualify for reasonable compensation, subtraction, modification, which goes along with the PSI deduction. So those are kind of there have been some more decisions that are on the tax tribunal website. If you're interested, kind of, I think we're treating 2 of them as kind of, one-off situations. And so if you wanted to read those, they're not really very significant. This is what's happening that is very significant in litigation right now. So, any questions? I'm always available. I have the same phone number, so feel free to call me and let me know if you want me to talk from my 10th floor office or my 11th floor. Thank you very much all for coming. I appreciate it.